Today on Bench Briefs, we're looking at a complex federal court of appeal decision that deals with Indigenous band membership, crown liability, and the tricky question of jurisdiction. The case is Dumais Estate versus Canada, decided in 2026, and it dives into who can be held responsible when it comes to membership services and benefits involving an Indigenous band, and which court has the authority to decide these disputes. So, what happened here? The Dumais estate launched a claim against Canada's Indian Affairs and Northern Development Department, seeking damages related to membership services and benefits connected to an Indigenous band. This wasn't just any lawsuit. It involved a default proceeding, which means the defendant didn't respond in time. So the court was asked to assess damages without a full trial. But the case got complicated because it raised questions about whether the federal court even had the power to hear the claim in the first place. The Federal Court Act sets out when the federal court can hear cases, and one key issue was whether the court had jurisdiction under Section 17 of that act to assess damages in default proceedings. This section deals with claims against the Crown, but things get tricky when there are conflicting claims or when an Indigenous band is involved. In this case, there were conflicting claims between the Crown and the band, and the court had to figure out if those claims fell under the jurisdiction of the federal court. Another big question was whether the band was acting as an agent or servant of the Crown when it came to membership services and benefits. Why does this matter? Because if the band is considered an agent of the Crown, then liability might fall to the Crown under the Crown Liability and Proceedings Act and the Indian Act. If not, then the band might be responsible on its own. Adding another layer to the dispute, the band tried to participate in the proceedings after its defense was struck out. This raised important procedural fairness issues. Should the band have been allowed to make submissions on jurisdiction despite its defense being struck? Would permitting or denying this participation violate principles of natural justice? These are not just technical questions. They touch on the fairness of the legal process and the rights of Indigenous groups to be heard in matters that affect them. So let's break down the key legal issues the court had to decide. First, did the federal court have statutory jurisdiction under Section 17 of the Federal Courts Act to assess damages in default proceedings against the Crown? Second, does the concept of conflicting claims in Section 17(4) include situations where there are divided obligations between the Crown and an Indigenous band? Third, was the band acting as an agent, servant, or officer of the Crown for the purposes of membership services and benefits under the Crown Liability and Proceedings Act and the Indian Act? And finally, did allowing the band to make submissions on jurisdiction after its defense was struck violate principles of natural justice and procedural fairness? Why does this case matter? At its core, Dumais Estate versus Canada highlights the delicate balance between federal authority, Indigenous self-government, and the rights of Indigenous bands in the Canadian legal system. It clarifies when the federal court can step in, especially in default proceedings involving the Crown and Indigenous entities. It also sheds light on the legal relationship between the Crown and Indigenous bands, whether bands are independent actors or agents of the Crown in certain contexts, which affects who is liable and who can be sued. This case also underscores the importance of procedural fairness, especially for Indigenous parties who seek to participate in litigation that impacts their communities. The court's handling of the band's attempt to intervene after its defense was struck speaks to broader themes of access to justice and respect for Indigenous voices in the courtroom. In the bigger picture, Dumais Estate versus Canada helps shape the evolving legal landscape where Indigenous law, federal law, and administrative law intersect. It reminds us that questions of jurisdiction and agency aren't just abstract legal concepts. They have real consequences for how Indigenous peoples and the Crown interact, how disputes get resolved, and how justice is administered. Thanks for listening to this episode of Bench Briefs. Join us next time as we explore another important case shaping Canadian law. Until then, take care.